Okay, good morning, good afternoon, everyone. Thank you for joining us today. My name is Brian Smits. I'm Director of Global Solutions here at Replicon, and I have the privilege of being joined by Brian Dixon, who is co-chair of the Wage and Hour Practice Group at Littler Mendelson. And during this webinar series, we're going to focus on challenges around global compliance. And today, webinar number 1, we're going to be talking specifically about U.S. labor law updates. So our agenda, we're going to talk about challenges around global compliance. Today we'll focus on the U.S. We'll talk briefly about how the time intelligence platform from Replicon can help overcome these challenges. And we'll review a specific customer example before we end on about 10 minutes of Q&A with Brian from Littler. So a few housekeeping items. You're on mute right now, and you will be during the presentation. The Q&A will be at the end of the webinar, but you can submit your questions at any time, and we'll be queuing those up through the administrator for Brian at the end. Okay, so top issues with global payroll. So EY did a global survey, and 27% of the multinational organizations that were involved and polled, they said that legislative compliance was the biggest challenge that they face. And we've got to tell you from a Replicon perspective, this is pretty consistent in our conversations and discussions with potential customers in the marketplace, that legislative compliance is definitely a concern. And as litigations go, it's pretty common to see labor litigations in the news these days. And there are various issues that can have an impact on organizations. And this holds true across countries and across industries. And in addition, there's a trend, and you've probably seen some of them happen to very high-profile organizations very recently. The trend is that many of these litigations can turn into class actions. And unfortunately, that carries higher liabilities and more negative brand impact for some pretty visible companies very recently. But why is it so difficult? Specifically here at Replicon, being a workforce management company, we specifically see that most organizations lack a unified system of time globally. And generally what we find is that disparate systems are deployed around the globe, kind of in a patch framework. And typically we'll see organizations that have large employee populations in certain countries automate there. But when you get to medium and smaller population countries for an organization, that's when you start to see the disparity come in. It can be local solutions, Excel, spreadsheets, manual, you name it. And that really creates some challenges. Getting that ready for gross pay and for payroll is a challenge. And without a global system of record for time, it's very hard to account for things like collective bargaining agreements, being up to date on a very, very fluid variations in statutory compliance and labor law. And it's very hard to be ready for audits as well. And the number of global locations directly impacts complexity, and it makes it harder to finalize gross pay accurately. And also, the more countries that an organization has, the harder it is to get a unified view of employees' pay and all those other things. So we'd like to have a poll. We'd like to ask you how many countries your organization operates in. A is less than 3, B is 3 to 10, C is 10 to 20, and D is greater than 20. So administrator, let's open the poll, please. And we'll give that about 20 or 30 seconds for everybody to click their answer. Okay, administrator, let's show the results. All right, less than 3 and above 20 are our two biggest groups. So lots of complexity out there. Thank you very much for that. Okay, let's proceed. Okay, so labor compliance in the U.S. is pretty multifaceted. We have a list here. It's not comprehensive. This is just a sample of the compliance items that need to be adhered to. We'll talk about work time today, overtime, scheduling, and many other things. And please, if there's something not on the list, we would openly invite you and welcome you to ask a question at the end of the webinar. Now, the Department of Labor here in the U.S. actually believes that 7 out of 10 companies are at risk of non-compliance. And if you look at the year of 2017, there were nearly 8,000 filings in 2017. And just the top 10 settlements alone added up to $2.7 billion. And that, that's a lot of lost revenue, and it hurt quite a few companies, but it hurt quite a few employees too. So, we look at it from the perspective of taking care of the employees, helping the companies as well. And if you look at the increase since the year 2000, it's been a stark difference, 450%. But overtime is usually the most common culprit at 42%. And generally, when you have an overtime implication, there are back wages involved per NERA Consulting. So, Brian, this is where I will kick it off to you, and so we can talk about issues around timekeeping and requirements.
Thank you very much, Brian. I really appreciate that. I want to thank Replicon for sponsoring this very important webinar and valuable to all employers. And I'm very pleased to have the opportunity to work with Replicon again in this regard. So, the key to wage and hour compliance certainly is good timekeeping. Most employers have some intuitive sense that timekeeping turns on having people use a time clock. Many employers, though, are cognizant of the federal rule and the rule that most states follow, which is the only thing a time card has to have on it is the total hours of work. Certainly, the more accurate your time card is, the less likely it is you're going to get claims regarding off-the-clock work or similar disputes. And we want to be sensitive to the fact that some states, California and Connecticut, for example, require clock times to be on time cards. You cannot simply log the total number of hours of work in a day. And the important consequence here is that if your timekeeping is at all inaccurate, if a plaintiff can show that your time system is inaccurate, it's not capturing all work time, then the burden of proof shifts to you as the employer to disprove the employee's claim. And that can be, and I've had in my cases, the nearly impossible burden of disproving an employee's claim after a timekeeping system has shown to be inaccurate. That's particularly true with respect to employees who work remotely, such as service technicians who may work from their home and go directly to job sites. But these days, one of the things that we have to be very aware of with the mobile workforces that we all enjoy and have the opportunity to work with is that employees who are office-based can often work from home. They may have the privilege of working from home a day a week, or they may be telecommuters who work from home on a consistent basis, or they may be, and we find this as an increasing issue, employees who are expected just to check their email at night or on the weekends, check in once in the evening, once or twice on the weekend just becomes the norm because that's what the supervisor desires, and that's what the supervisor expresses disapproval about if it's lacking. And when those employees are non-exempt employees, we certainly need to have a flexible timekeeping system that can capture those small amounts of time. And that is the subject of our next slide. Brian, if you could take us there. We'll be talking about de minimis time. A long time ago under federal law, and we do need to advance to the next slide. Under federal law, a very practical rule grew into the compensation of employees, and that is the de minimis concept. And the de minimis concept looks at three basic things. It looks to see if a particular activity that the employer is not recording or paying for is how long is that activity, how regular is that activity, and how difficult is it to record that time. And back in the day, so to speak, in the this doctrine came into federal labor law in the mid 1940s. Recording work time was a real challenge, and I think a court's expectations were relatively low at that point in time. A lot of employers had timekeepers who really, one of their major activities was to sit at the door to the factory and record the time when each individual came into work. Well, we're way beyond that. And one thing that I think is happening is that the court's expectations are slowly increasing as to what the baseline is for an employer. And one example of that is, for example, a recent case involving a casino in Las Vegas, where the employer was not capturing short, 5-minute pre-shift meetings that occurred every time the croupier and the dealers and the other service personnel came on duty. And the employer said, look, we have the de minimis rule. You look at duration of activity, regularity of activity, difficulty in recording the time. And the employer also pointed out that de minimis rule had just about become a per se rule in some people's mind, that you can exclude up to 10 minutes of work time per day. And there were many federal court decisions to that effect. Here, the court said, I see all the decisions excluding 10 minutes of work time, but let's look at the criteria. The activity is not particularly long, but it's very regular. It happens before every shift. And you do have a timekeeping system. So what's the difficulty in allowing people to add 3, 4, or 5 minutes to their time to reflect this consistent activity? So first takeaway here is that even under federal law, the de minimis rule is not a per se rule that allows or excuses sloppy record keeping, particularly if the activity is consistent. And then, and here, let me take a step back. My approach today is going to be using California, which is often the most challenging state, if not very much the most challenging state, in which to do business from a compliance point of view. And I'm going to use that as a point of contrast against other rules, especially federal law here in the United States and in other states. So we have a number of recent California Supreme Court decisions to discuss. The most recent one is a case called Trester. And Trester involved an individual who worked at a fast food service location. And he was the assistant manager, shift leader, who was responsible for closing the store at the end of the day. And the shutdown routine was he would punch out, and then he would escort employees to their cars in the parking lot for security purposes, a very good practice on the part of the employer. He would be responsible for pulling a couple of chairs and tables that sat outside the restaurant into the restaurant, and if some employee ran up to him at the end of the turnover period and said, I forgot my briefcase, my lunchbox, my purse in the store, he would unlock the store, let them in, and leave again. And the amount of time spent was 4 to 12 minutes per day. And the employer did not dispute that. And the case went to the California Supreme Court under the de minimis doctrine, and the employer, of course, is saying this is the de minimis amount of time, pointing to the federal rule. It's followed in every other state. We should follow it here. There's actually, in the California Civil Code, there are principles of jurisprudence, one of which was ignore trifles. And the Supreme Court said, no, when we pay employees, we are concerned about trifles. Employees should be paid precisely, and small amounts of time matter. And while the court did not say that there would be a failure in California to consider the de minimis rule, the court did say in these circumstances there is no de minimis exclusion. And it's fairly ironic. The claim got to the California Supreme Court on 4 to 12 minutes of work time a day. The employee's total claim, I think, was somewhere between $100 and $200, but nevertheless, that's the decision. Well, what are our takeaways here? As a practical matter, we need to be thinking about, you know, what were the essential characteristics of the case, and they were that the activity was consistent. It happened every day. And the second thing that, and it was actually, in a sense, built into the shutdown policy. The other thing is that the employer didn't dispute knowledge of the activity. There was no issue. We are, as employers, responsible for all work which we suffer or permit. We know what permit means. That means I allowed it. What does suffer mean? Suffer. Can we have work time inflicted on us? And the answer is, to a degree, we can. If we know about something and we don't stop the activity, we are responsible for paying for it. So here you have consistency and you have knowledge, and we just need to be aware in the future we're going to have to capture that work time, particularly here in California. In addition to, and most of the issues here I think are going to fall in a couple of categories. One is opening up and shutting down, starting up and shutting down, logging in. Across the United States, there are a lot of call centers. Whether there's if you consistently have 2 or 3 minutes of login time, if your call center or your facility here is in California, we need to be capturing that time. Another, I think, is we go back to the expectation that employees will check their email every evening, will check it once or twice on the weekend, where, if that's really an established expectation, we should capture that time, budget for that time, and pay for that time. And that tells us that we need increasingly flexible and mobile record-keeping, timekeeping solutions to keep up with where the law is going. And Brian, can we go to the next slide and we'll talk about rounding for a minute. Rounding time has also been embedded in federal labor law for a long period of time. Basic rule is fairly simple. That is that you can round time as long as the employer and the employee share equal benefit and burden of the rounding practice. That is, it doesn't work out in the long term to benefit the employer or the employee. It's neutral. The other rule is that you can't round work time beyond an increment of 15 minutes. Can't round to the nearest half hour. Sorry, that's not allowed. But here's a little sidelight on rounding. I had a client recently, a local hotel here in San Francisco, that received their next edition of their handbook from corporate headquarters, which was located in the central United States. And the managers were just very surprised that the tardiness rule had changed, and it now said that you're only tardy if you're more than 7 minutes late. And they couldn't figure why that was. And I said, you know what it is? It's actually a very astute perspective on the rounding rule. It's astute in the sense that if you have a strict rule that says everyone has to be here on the moment that you punch in, everyone's going to have to show up early. And the odds of there being an equal benefit or burden to the employer, between the employee and the employer, in the sense that in the long run it sort of averages out, is greatly diminished by that kind of a rule. May not evaporate, may not go away, but it's diminished. The other thing we want to be sensitive to is that if you round to the nearest 15 minutes, all your work activities have to start and stop on the hour, the quarter hour, or the half hour. So you can't have a pre-shift meeting that starts 5 minutes before, say, the shift starts at 8. We expect everyone to be in the pre-shift meeting at 7:55. If you're rounding up to 8 o'clock, you're not going to have equal benefit and burden. Couple other pointers here. I thought it was interesting. The largest class action I ever had, which actually involved more than 100,000 employees, was a rounding class action. And when we sifted through the data, very fortunately for this employer, which had very widely varying schedules, so we had sort of an intuition that rounding might be okay because people started at all different times of the day and left at all different times of the day, and there wasn't like a whistle that blew and an expectation you'd be there at the, when the clock struck the hour. But the interesting thing was to see how some employees obviously knew that the rounding rule existed, and they helped us while they were taking advantage of it. At the end of the day, some employees were gaining an extra 20 hours of time in the course of a year than they were, because they knew what the rounding rule was, and they knew to wait and pause to punch out at exactly the right interval. And, while in the general scheme of things that might not be good, it helped balance out a lot of people who seem to be less aware of the rounding rule, and they'll help keep the average in place. But one of the important things to realize is that your timekeeping system, every timekeeping system, keeps the actual punch-in time in its memory. And so a plaintiff can come in and get from your timekeeping system the actual punch-in times down to the second usually, and hire an expert, do the statistical analysis, and tell you whether your rounding is working to your benefit or not. One of the most interesting little sidelights here is I had a worldwide technology company, footprint everywhere, recently that was trying to rethink its timekeeping system and its philosophy, and their inclination was to go back to hand entry of time by non-exempt employees, on the thought that employees will simply round their time on their own to the nearest, quarter hour or 5 minutes, and they were willing to accept, because they're a worldwide technology company, they could crunch any number, but they were willing to accept employees' recording of their time as opposed to an electronic recording system. The best practices here are really these. Your best paying employees to the minute. If you're worried about the fact that people may punch in and then have to walk to a work area, or they punch in, they go to the coffee room or the break room and then the locker room and then they go to the work area, your answer is more time clocks near work area. And with today's technology, that's an easy thing to accomplish. So let's go on and talk around meal periods, or about meal periods. Across the nation, about half the states require meal periods. And the general rule is a meal period has to be at least 30 minutes long, and an employee has to be relieved of all duty during the meal period. After that, you wind up with extreme variations in what states expect. On the federal level, frankly, federal law doesn't require you to provide a meal period. If you can keep your employees on their feet for 8 straight hours and not feed them, you are not in violation of federal law. But again, half the states have an affirmative requirement for meal periods. And I think in the other half of the states, everybody understands that you better feed your staff or you're going to have a mutiny. But in those states that are particular, we need to realize there are wide variations. For example, in New York, there are particular brackets of time within a shift that you have to have a meal period. Most states simply say that you have to have a meal period or provide the opportunity to have a meal period after a certain time interval. For example, it's often it's 5 hours here in California. You have to be able to start a meal period before you work 5 hours. That's your basic rule of thumb. Some states are 6 hours. Some states simply say you just have to provide an employee the opportunity to eat. In hardworking Illinois, a meal period could be only 20 minutes long, but they're the federal rule that, if a meal period is going to be non-work time under federal law, that is, and again, federal law doesn't require meal periods, but if you don't want to pay for a meal period, it has to be at least 30 minutes long. The employee has to be relieved of all duty. Let's talk a little bit more about California, because California drives the analysis in meal periods, and it does so because in California, if you do not provide the opportunity, and I will underscore the word the opportunity, for an employee to start a meal period before the employee works more than 5 hours, you have to pay an extra hour of pay. It's called premium pay. All of us think of it as a penalty, but the California Supreme Court has told us that it's actually pay, not a penalty. And that's significant because the statute of limitations for a wage claim goes back 4 years. So for not providing meal periods, an employee could, that's just conceivably, there are about 260 work days in a year, take off 10 for vacation, go back 4 years, you got 1,000 work days. We reduce that a little bit maybe for holidays and sick and other absences, but thinking about 1,000 work days in 4 years, you could have 1,000-hour liability towards an employee, very material potential liability. So in California, to have a compliant meal period, because your obligation is to provide a compliant meal period, you have to give the employee the opportunity to take it on time. It has to be at least 30 minutes long. It can't be interrupted, and you have to be free to leave the premises. And I think there's only one other state that I know of where you have to be free to leave the premises. I believe that's Nebraska. And, to leave the premises in California is an interesting requirement. You'd think that the court would be focused on employees having rest and nourishment, but I always think of the free to leave the premises requirement to mean that you have the opportunity to run out and pick up the dry cleaning. So there's a little bit of mixed motive here. The important thing to realize is this. You do have to provide the employee the opportunity to take a timely, compliant meal period. Some employers will allow employees to skip their meal periods because the employee wants to leave early. If you do that, we obviously need a system to record that employees had the opportunity to leave and didn't. And that's usually, the best way to address that is to have a daily query to the employee through the timekeeping system, a pop-up, so to speak, that did you have an opportunity to take timely, compliant meal periods today? Yes or no? And same question for rest periods that we'll come to in a minute. And that allows you to have an ongoing record as to whether employees waive their meal periods. One of the things that I will say, apart from a timekeeping system, one of the things that I will quite frankly say I preach, is that even with a pop-up button, you can run into problems. I have a wage claim now where the employee says, my manager told me it was a busy retail environment at a resort. The manager coerced me into pushing. It told me I always had to push the button. Yes, I had the opportunity to take my meal period even when I didn't. So the lesson, the takeaway, the ultimate takeaway on meal periods is we need a accurate recording system. We do need the pop-up button, and your best proof that the opportunity to take a timely, compliant meal period was provided is that you actually required the employee to take the meal period and to accurately record it. And again, accurate recording is your ultimate way to good compliance in that regard. So Brian, why don't we go from meal periods on to rest periods and chat about rest periods for a moment. Rest periods, oddly enough, are required in many fewer states than meal periods. If you look across the United States, there are only about a dozen states that require rest periods. The usual criterion is when an employee works a certain number of hours, you have to have a rest period in the middle of that period of time. Here in California, again, and most states don't have a penalty that the employee can claim for a missed rest period. In most states, the most that would happen is someone complained to the local Department of Labor. You might have a visit by your friendly local Department of Labor representative and a query about providing rest periods and making sure you comply with the local law. And again, there's only around 10 states that affirmatively require rest periods to be provided. The rest periods are fundamentally different than meal periods in the sense that you have to, rest period is considered work time. A rest period is considered non-work time only if it exceeds 20 minutes during the day, and the employee is free to use the time for whatever purpose he wants or she wants. And so brief intervals in the day where, say, the machinery goes down, or these days the network goes down temporarily, aren't going to get you non-work time. They're simply a compensable rest period. Here in California, we have two challenges. One is we want to have some record that, in fact, rest periods were provided to employees. And if you don't have to punch out for a rest period, what are you going to do? Some employers, very, very, very few, have their employees punch out for rest periods, but that's not really your best practice, because inevitably people won't punch in and out that often, that frequently, twice a day for my rest periods. And you begin to build a sort of reverse inference because of the missing rest period punches that rest periods weren't provided. So again, a radio button at the end of the shift that says, did you get your rest periods, is your best solution. And, it doesn't have to be a button. It can be a field. It can be a click mark, a mouse click that could provide you the answer. The important thing we want to appreciate here in California is that there's a recent decision called Augustus, in which the California Supreme Court said that a rest period also has to be free of all duty. You have to be not even obligated to be listening to your radio during a rest period, and that can be a challenge if you're the only security guard on duty. Here in California, you can turn off your radio for 10 minutes twice a shift, which can give rise to some security concerns. But again, you can wind up paying the premium if you don't do that. Brian, let's talk about another state and its rest period obligations in Washington. Washington is sort of an activist state on rest periods. Maybe it's just the opportunity to go out and get another coffee from one of their many fine coffee provisioners. But In Washington, if you miss a rest period, you get 10 more minutes of pay. In California, and the value proposition in California is a little different. If you miss a rest period, you get an hour of pay, but you don't get work time. It's just an extra hour of premium pay. In Washington, those extra 10 minutes count as work time. You have to have a record-keeping system that's flexible enough to allow you to add that work time, because it also counts towards overtime in Washington. Okay, Brian, let's go on and talk about a subject that most employers don't worry about too much, but I think it's important to touch on for a moment, and that is tracking sleep time. And we're going to talk about sleep time here, not in the sense that I'm asleep at my desk or I'm asleep on my feet or I'm asleep leaning against the wall. We're going to talk about sleep time in terms of something that happens structured in the employment environment. I'm going to touch on it briefly because it doesn't concern that many employers. This individual who's lying across his desk does not have to be paid for that time. It could be a rest period, so we have to watch out for that. Maybe you have to stand there for 20 minutes to count out the time when you can start saying, this is not your rest period. That would be important, or you might discipline him for creating a safety hazard because he might fall out of his chair and hurt himself. You can see on the screen the basic rules for when sleep time is work time. I want to emphasize that if someone actually resides on the premises, which happens in domestic employment, for example, you might have a live-in person. There's a different rule, and that is you look at what time an employee is actually working, because they're working and living at their residence. They're working at their residence, and the dividing work time is different. But there are a few things that if you do have an employee asleep on the premises, you want to be aware of, and that is you need to have employees punch out for their sleep period. And that's something that very few employers do that have sleepover employees. Employers do that have sleepover employees. They simply expect to deduct 8 hours when, in fact, that's a record-keeping issue, and we need to have a record of that. You also have to be able to record interruptions of sleep at night. If someone has to get up and attend to something, an alarm goes off, whatever, you need to pay for that. The third requirement that a lot of employers miss is that you can only exclude sleep time on shifts of 24 hours or more. And I've had a lot of cases in the group home industry where the shift isn't quite 24 hours. So if you're going to exclude sleep time on shifts, you need to block out, where's my 24-hour cycle for each exclusion of sleep time. And Brian, we're going to go on here and talk about a special rule here in California. In California, oddly enough, sleep time can be work time. Life is good. You can be, surfing in your dreams and be paid for it here in California. There's an odd decision, another recent decision from the California Supreme Court. You might notice a little bit of a negative trend here, where the Supreme Court took a very narrow view in California's wage orders. There are 15 of them for different industries. They pointed out that there was only a specific exclusion of sleep time in one of the wage orders for ambulance attendants, and therefore there can't be any exclusion in any of the other wage orders. A very surprising decision. I think it surprised even the California Labor Commissioner, but such is it. And what we're seeing now is a lot of claims for employees who work in the field who, in the past, the employer sort of intuitively thought, if you're asleep, I'm not having to count that as work time. And we're seeing a few heartbreaking cases in the domestic employment arena where people sleep over. They're not residing on the premises, but they're sleeping over 3-4 days a week. Then somebody else comes in and provides care for an elderly or disabled individual. And we're getting a lot of claims for, I want to be paid for 24 hours a day. So again, that's just a cautionary note. We have to be very, very conscious of that. Many of you may be aware that both Congress and here in California, there were recent changes in the law to provide additional overtime protections for domestic workers. If we're employing domestic workers, we have to be very sensitive to that. So Brian, let's talk about a few scheduling challenges and look at our next slide. So there are a couple recurring issues in timekeeping systems that we need to be aware of. And one of them, if you happen to have 24-hour operations, or even shift operations in some cases is what happens if my workday crosses from one work week into the beginning of the next work week. We all have to have a work week. It should be in our handbook. It should be posted. It should be defined. And whenever we cross from one work week into the next or one work week to the next, the counter starts over again in terms of we're counting towards 40 or 8 hours in a day. The only statutory exception to that is Colorado. Colorado, interestingly enough, you have to pay overtime based upon continuous shift hours. So again, a timekeeping system that can track that it can incorporate rules that allow you to track continuous shift hours is going to be very important in Colorado. But let's go to every employer has a work week. And at the beginning, when you come back to work on, say if your work week is the calendar week, Sunday to Saturday, you come back to work Monday morning, your counter starts over. Well, the counter started over, Saturday at midnight. What if your shift starts Saturday at 10 p.m., night shift, 10 p.m. goes to 6 a.m. Sunday? Well, you've got 2 hours in the prior work week that have to be counted as overtime, and 6 in this work week that have to be counted towards overtime. A lot of timekeeping systems will throw all those hours into one work week or the other, and that's not correct. That is not compliant timekeeping. So you need a system that can address that issue. We talked a little bit about overtime based on continuous hours there in Colorado. Another one which I find fascinating is I can still remember the first time that a client called me up and said, we've got an employee who's going to Singapore on business. And I was going, well, that sounds sort of nice. They said, how do we keep his time? And I was thinking, after a while, I began to realize that we probably want to keep the time in continuous California hours, because otherwise we'd have to have a change of work week and go through all the perambulations of changing the work week. And the employee is only going to go for a week, so we kept him on continuously on California time. I do have to say I was stumped when the client came back and said, what about the international date line? We're going to have an extra day. And I'm going, we finally worked out a solution. But really, when you have employees who are traveling more commonly across time zones in the U.S. and they're non-exempt employees, the easiest solution is to keep your time in the hours of the home office. And if all of this is not enough of a challenge, let's turn our page one more time and talk about paid sick leave. Paid sick leave is, as all of you know, and I heard that many of you have more than 20 locations, the bane of every employer's existence. We could spend easily half a day talking about paid sick leave, but it would probably make us all ill by the time we're done. So I'll just focus on a couple of high points here. We've got states, cities, and municipalities all imposing paid sick leave. A lot of it is a reaction to the current administration. The Obama administration was a very activist administration from changing labor laws. The Trump administration is not. So we see a lot more activity at the city and county level than we have in the past. Paid sick leave laws, a lot of employers say, what's the issue? I always provided sick leave, but the thing we have to keep an eye on is that the potential uses for paid sick leave are often much broader than they are for a conventional sick leave policy. Here in California, my inclination, and actually looking across the United States, not just California, the only thing that I think is excluded from the use of paid sick leave is taking the dog to the vet, and I'm sure we'll get there soon. The challenges with paid sick leave are you have different mandated accrual rates. You have different caps on how much can be accrued. You have different annual use amounts that are the maximum use amounts. And they often, just to make things really heartburnish, they conflict. Here in San Francisco, for example, we have a state law that has a very convenient paid sick leave law. If you grant an employee 3 days of paid sick leave once a year, you pretty much discharge your paid sick leave obligation. Employee gets to use them. You can't authenticate the use. It's like 3 days of just paid time off, some cynics would say, but it gives them, the employees the opportunity to use that sick leave for a very broad range of purposes. San Francisco, on the other hand, has mandated accrual rate and no upfront advance. San Francisco doesn't have an annual cap on accrual, or the cap operates actually over a 2-year period, not a 1-year period. So you immediately have the need to be extraordinarily nimble in providing paid sick leave. I have a few clients who just have given up on terminating employees for absenteeism. They said it costs less to do that than it does to have a compliant paid sick leave program that covers, all the states in which they do operations and each little municipality's variations. Some employers go for the middle of the road. They distill all the requirements to a core sort of lowest common denominator, and then they worry a lot when it comes around to terminating someone for absenteeism. But we do need to track it. We need to be able to label its use. We need to accrue it, track its use, and in some states export the accrual and use onto the pay stub. And why don't we take a look at statutory overtime needs, which is our next subject. Most of us are familiar with the federal 40-hour overtime standard. It's been with us at the federal overtime law, I think, started at 48 hours, overtime after 48 hours a week back in 1938, and then it came down through a series of steps, 46, 44, 42, 40, and landed on 40 hours sometime in the late 1940s. States are free to vary the overtime obligation in multiple regards. They can say, when do you have to pay overtime? They can change the rate at which you have to calculate overtime, and they can change what activities count as hours of work towards overtime. A lot of employers get focused on, there's a different overtime threshold. They're not thinking about how you calculate the overtime and what activities have to be counted towards that threshold. Our daily overtime states, Alaska, California, Oregon, only for certain, I think, lumber-related employers. Nevada recently changed its law so certain lesser-paid employees get daily overtime. Kentucky has seventh-day overtime premium. So that's, a summary of your different obligations across the United States in terms of variations from 40-hour overtime. A lot of employers here, for example, in California, you have alternative work schedules. Very elaborate process for getting, going to 4 10-hour days instead of 5 8-hour days. You have to make sure you go through the process. The end of the process is you have to submit your schedule to the State Department of Labor. The State Department of Labor will post it on a website. Plaintiff lawyers will look, if they find an employee who's working 4 10-hour days and you're not on the website, you're going to get sued in a class action for a lot of overtime. So we have to be mindful of that. And we also have to have a timekeeping system that will allow you to flex to show overtime after only 10 hours of work in a day. I had a client, another international technology company, some years ago. They had embedded 8-hour overtime in their timekeeping system. So when they had a 4-day per week, 10-hour day schedule, they would tell the employees, just put down 2/3 of 2 hours of overtime every day, and then we multiply that by time and a half, you'll come up with 10 total hours for the day. Not a solution. We had a very interesting meeting with the United States Department of Labor about that issue, and the major challenge was getting over the incredulity of the Department of Labor that we could not do a better job of calculating overtime. And we can create additional burdens for ourselves, either voluntarily or perhaps involuntarily, less voluntarily, through union negotiations. And Brian, why don't we take a look at our next slide, non-statutory pay obligations. And we just need to appreciate that in many both union and non-union environments, an employer can adopt the obligation to pay additional overtime or other premiums like shift premiums, lead person premiums, for lead people, different kinds of work premiums. And one thing that's of a recurring note is, especially with all the living wage ordinances that are enacted on the county and municipal level, your rates of pay have to vary by geographic location these days. You have to be sensitive to that. Here in the San Francisco Bay Area, your rate of pay can vary as you drive from San Francisco to San Jose, both of which have living wage ordinances. And if you go up the East Bay through San Leandro, Emeryville, Oakland, and Berkeley, you make a loop of the entire bay, be a nice drive, your living wage rate changes from one municipality to the next. And there is, setting aside the horrible challenge of, do I have to change the wage rate because you stopped at a stoplight in San Leandro on the way to Berkeley? We just, we have to have be sensitive to those living wage ordinances. I have actually suggested to the California Chamber of Commerce that they actually encourage the legislature to pass a labor law, which would be that a living wage ordinance will only be valid in California if it's filed with the labor commissioner and posted on their website, because one of the greatest challenges for employers, as I'm sure you all know, is trying to figure out if a municipality, in fact, has a living wage ordinance. I mean, there's no register of all those challenging things. And let's go on, and we'll take a few minutes here and then wrap up for our Q&A. For regular rate calculations, one of the things that I emphasized earlier is when we look at compliance across the United States, we need to be able to think about what activities are work time, capture those, and record those. We have to know what is the threshold after which we pay overtime, and that again could be a state obligation. It could be from a union contract. It could be just as a matter of policy. A lot of employers, for example, pay time and a half for work on holidays. They adopt that burden voluntarily. And lastly, you have to know the rate at which you're going to pay the overtime. And because the rate can vary based upon location, you need to be able to identify where hours are being worked when they're processed into your payroll system so that you can do the appropriate calculation for that location. And the greatest example of that is fairly simple, and that is under federal law, you basically divide all of an employee's compensation into two buckets. One bucket is called the regular compensation. It's things we intuitively include in the overtime calculation: your hourly rate, your shift differential, your lead person premium, your commissions, just about all of your bonuses. The fact that a bonus is discretionary doesn't necessarily mean it's excluded from the regular rate calculation. And you get one bucket. The other bucket are things that are excluded from the regular rate. They're identified by statute. They include things like health insurance, business expense reimbursements, retirement plan, reimbursement of business expenses, holiday pay, sick leave pay, vacation pay. Those things are in the other bucket. And we take the first bucket, actually. Under federal law, it's fairly simple. You take all the regular compensation, you divide it by the hours worked, and you pay 1/2 of that result for overtime. It's a half-time calculation. Under California law and the law of about half a dozen other states, they reject the federal calculation in this regard. If you're just paid, you take a non-exempt employee, you pay the employee a salary. The employee works 42 hours, you divide the salary by 42 hours, you get an hourly rate, you pay halftime. If they work 50 hours, you do the same math, but the halftime rate is dropped, and you do 60 hours, and it's dropped even more. You might even run into a minimum wage problem. And for that particular category of employees who are paid by salary, that kind of a pay plan, fluctuating workweek pay plan, results in a diminished halftime rate as an employee's hours grow. And there are about half a dozen states that have rejected that. California is one, I believe Alaska is another, and right off the top I can't remember the others, but we have to be aware of that. And it comes back in a major way when you have a misclassification case. Someone claims, I should have been paid overtime, I wasn't paid overtime. Under federal law, you would divide their salary by their total hours worked, and they're claiming and pay halftime. Under California law, you divide it by 40 maximum straight time hours, and you pay time and a half. One little spin that came down recently in a case called Alvarado, California Supreme Court said the same rule about how you calculate overtime on a salary applies to lump sum bonuses. If you pay somebody $100 as an attendance bonus at the end of the year, and everybody gets $100 regardless of how many hours they work, you divide the bonus by the straight time hours worked during the period of time the bonus is earned, and you pay time and a half on the bonus. That's focused a lot of plaintiffs' lawyers on the appropriate calculation of overtime. It's what we call regular rate class actions are very a boon to plaintiffs' lawyers because your timekeeping system pays everybody the same way. So it's like an instant class action. If the formula is not correct, you're going to have an overtime liability. The result of that is we do a lot of regular rate audits for clients, basically sit down, go through all your pay codes. They should be defined. Their scope should be defined in writing. go through all the pay codes, determine if they are in fact going into the overtime calculation or not. It's not an extraordinarily difficult complex. Complexity can grow depending upon if you have multiple union contracts and a lot of different pay codes. But doing a regular rate audit is a very prudent thing to do today because plan lawyers are very attuned to it as a potential source of an instantly certifiable class action. So on that, I'd like to end on the note that there are risks out there. There's a lot more class action litigation, as Brian mentioned. There are easy ways to remediate your primary liabilities. Do a regular rate audit. Make sure your employees are classified appropriately. Have an internal audit procedure. Just have somebody in payroll call up 25 employees every payday, randomly chosen, and say, are you being paid correctly? Do you have any issues with your pay? Are you working off the clock? And most importantly, have a timekeeping system that can provide the flexibility and the accuracy you need in order to pay people accurately. And with that, Brian, I think the program's back to you.
Perfect. Thank you for that insight, Brian. We definitely appreciate that. And per the thought process of having an accurate time system, that's where Replicon comes in. And I'll tell you about that very quickly. But first, we want to poll the audience to see, how organizations are managing labor compliance. We'll be quick here so we can get to the questions. Administrator, please show the poll. Okay, so A is manual, B is outsourced, C is local systems or processes in each country, and D is all of the above. Okay, administrator, let's see the results. All right, so 54% is manual, so half the group is doing it manually, and 20% is doing all of the above, including outsourcing. Okay, so that's typically what we see. I'd like to keep moving here. Okay, so this is where time intelligence comes in, and our platform can solve all of these challenges, not only here in the US and all the issues that Brian talked about, but abroad as well. And I'll be very brief so we can get to the questions. Multinational organizations face a lot of complexity from multiple countries, multiple locations within those countries, multiple entities within those locations, lots of different employee types. They don't sit at desks, all of them anymore. There are collective bargaining agreements, work councils in Germany. That creates complexity for pay, for PTO, has to be done in a different format for each country. That's where a provider like Replicon comes in. We can handle all of those solutions, and we can solve this problem. And this is the way that we generally see organizations approaching payroll leakage, controlling costs, and trying to be compliant, is that it's a patched network of things. Large countries with large employee counts are automated, and it goes down to Excel or manual from there. And it's not really out of bounds for us to see a 10,000 employee company with 36 or more time systems. And really, this is kind of how we approach that. And I'll be quick. We have at the left, time capture. At the right is where we interact with our clients through the solution. We grab time signals in structured and unstructured. Structured is us interacting with the employee. Time clocks, phones, iPads, computers, those other things. Unstructured is where we're getting time data from a system that already exists in the ecosystem. Gate access, security, telephony systems, those kinds of things. Now, we provide context to all of that information. We look at in and out punches, we look at PTO, we compare that by location, by schedule, and activities, right? Applying time to different jobs, different tasks, all of those things. Now, the rules platform is where we configure it specifically to each client. We capture the time, we normalize it, we validate it, then we apply compliance. Compliance can be federal, it can be state here in the US, it can have collective bargaining agreements, all of those things. Then we apply the proper pay rules in the proper format, and we send it through workflows to the right groups all over the world. And in this case, the client is using compliance services. So the compliance lives in the technology, and then our team here at Replicon monitors for changes to statutory compliance out in the field. Here in this case, we're sending payroll information to a payroll provider through our workbench. We're getting employee demographics from an HRIS system through an integration, and we're doing global time off, and we're doing it in a single platform. And the other thing that I'll say on the previous slide, generally we're seeing disparate deployments because traditional time systems that are available commercially here in the U.S. to multinationals don't scale. They don't scale up to 10,000 or down to 1, and that's where this platform comes in, and we're able to do that. We offer compliance services in 60 countries and growing, and the system is also delivered in 20 or more